And good morning. The matter before the court is Jennifer Owen versus Town and Country Federal Credit Union, BCD 23442. We are being streamed live on the web by both video and audio. I would ask counsel who are arguing to introduce themselves by saying their names for the record, starting together with the party you represent, starting with the appellant.
Danielle Quinlan for the appellant, Jennifer Owen.
Peter Hale for the appellee, Town and Country Federal Credit Union.
Thank you. And Ms. Quinlan, if you're ready to proceed, we'd be happy to hear your argument.
May it please the court? Good morning. My name is Danielle Quinlan, and I represent the plaintiff appellant, Jennifer Owen. There are two issues on appeal in this matter. The first issue relates to the court's order on spoliation and granting defendants' request for attorney's fees related to spoliation. The second relates to the court's erroneous evidentiary rulings on comparator evidence in trial, even after the defendant opened the door on multiple occasions. So I'll take the spoliation issue first. On February 2nd of 2022, the court granted defendants' motion for spoliation related to and provided sanctions in the form of an adverse jury instruction, as well as attorney's fees related to obtaining the discovery at issue, which was the text messages the plaintiff, Jennifer Owen, had exchanged with a coworker, Jessica, formerly Dutton, now Walker. However, at trial, after having the plaintiff go through her testimony and going through the 7,000 text messages that were produced after defendant obtained the phone and downloaded all of the correspondence, the court reversed its earlier ruling on the spoliation issue and found that the text messages in question were innocuous and not relevant or providing any additional information towards any issue that was in controversy or related to the trial. However, the court refused to also reverse its ruling regarding the attorney's fees that it granted to the defendant in relation to the spoliation order for these text messages.
Counsel, I see that the green light is on. You would agree with me, I assume, that in its power to oversee discovery, the court has the power to impose sanctions, including attorney's fees. Do you agree with that?
Absolutely.
And in this case, the motion, I understand your focus on spoliation, but the motion from the defendant was a motion to dismiss sanctions for both spoliation as well as failure to comply with discovery.
My understanding, after reviewing the court's order, was that the order was on defendant's motion to dismiss and for spoliation. It was a motion for motion regarding spoliation and a request that the adverse or the sanction be dismissal of the case in its entirety.
The motion itself, and I'm looking at it at page 47 of the appendix, says it's a motion to dismiss and for sanctions against plaintiff Jennifer Owen for spoliation of evidence and failure to comply with discovery obligations. And in the opening paragraph, it similarly says dismiss and sanction for spoliation of evidence, misleading and or untruthful statements under oath, and failure to comply with discovery obligations. And then when the judge, and so that's why I started off with, you agree that attorney's fees can be imposed as a sanction for discovery problems, correct?
Yes, absolutely.
And then when the judge did the order, which I understand talks about it being a spoliation order, the judge does specifically say that the party was not cooperative in producing records, denied the existence of records, and that as a result, the defendant devoted a great deal of time and energy, which would have been unnecessary if produced in a timely fashion, that plaintiff needlessly drew out the time and expense of discovery and then imposed sanctions of attorney's fees. That sure sounds like a discovery sanction to me.
Well, it was a sanction related to the spoliation, and I think the specific award was for pursuing text messages, similar discovery-related issues, and discovery related to a third party, Jessica Walker, who plaintiff had no control over, so she should not be paying for defendant's costs for obtaining or pursuing discovery that was in her custody and control.
The sanction was for the effort and the time and the expense that the defendant had to go through in this process, partly occasioned by some of the responses that were received from your client. And at the end of the trial, when Attorney Loranger asked to have the attorney's fees withdrawn or canceled, the judge was quite clear. No, I'm going to leave it stand because of the discovery violations. Would you agree that we're reviewing this with from an abuse of discretion standard?
Yes.
And as the chief suggested, judges have pretty wide discretion, do they not, in sanctioning for discovery violations?
They do, but only if the defendant can establish that she was withholding probative discovery evidence. These text messages that were obtained, I should give a little more clarity.
The problem, the issue I think for the judge was it took a lot of effort, repeated discovery requests, several requests for production of documents, maybe 2 sets of interrogatories, maybe 2 depositions. This took an extensive effort equals expense on the part of one of the parties. And I think that's how the judge was looking at this.
And how we should have looked at it, in plaintiff appellant's opinion, is that it was really like a dog chasing its own tail. The defense spent a lot of time and their client's money chasing down these text messages that plaintiff had repeatedly said were not about the substance of this case.
But the problem is that the plaintiff also had, in fact, deleted those text messages, and there was some misleading statements about that as well, and whether that had occurred.
She didn't delete the text messages. What happened was she obtained a new phone and gave her old phone to her daughter. She assumed that the text messages would be backed up to the cloud. So it's one of those very...
But you have a finding by the court. It says, the court concludes that Owen intentionally deleted those communications in order to make them unavailable to Town and Country. In doing so, Owen violated her duty to preserve relevant evidence and prejudice Town and Country's ability to defend the lawsuit. So the court is making an express finding that she did this intentionally to keep it from the other party.
And the only basis for which the court made that decision was that she gave her daughter her phone 4 days after getting the right to sue from the Maine Human Rights Commission. We're talking about somebody who is not...
So are you saying that the court couldn't make that finding? There was not evidence in the record that would allow the court to conclude that she intentionally deleted the communications?
There was no evidence in the record to conclude that. And in fact, the court, upon review and the trial testimony of all the text messages and what happened to our prior text messages, reversed its ruling on the spoliation.
Well, more on the
order.
basis that the text messages were actually relatively innocuous, as it turns out, right?
Yes, Miss Walker and Miss Owen, they're good friends. Miss Owen is also Miss Walker's landlord. They live next door to each other. They help take care of each other's kids when one isn't with the other. Most of the text messages were those exchanged between girlfriends.
Okay. Can I go to the other issue about the admission of either comparator or Me Too evidence? What evidence was it that you wished to proffer into the case that established that the defendant does indeed discriminate on account of disability or otherwise treat employees differently on I think it was on a disciplinary issue?
Sure, Miss Walker, formerly Miss Dunton, was also an employee of Town and Country Federal Credit Union.
And was there something that established that in fact she was fired on account of a disability other than her saying so?
She was fired when she was 8 months pregnant, while also
Okay.
had
Is that something, though, that was established, like that either the defendant admits or that was established as by a court or something like that?
There was no fine, sorry, she was 8 months pregnant and had also been recently injured on the job and had
Okay,
a number
accepting
of
those
work
facts.
restrictions. But there was no prior trial. That case
Okay.
settled.
So isn't the judge's view that essentially we'd have to end up having a trial within a trial at that point? Isn't that supported because it wasn't a fact that was otherwise established? It's my understanding the defendant would object or would dispute, rather, that she was fired on account of a disability. I mean, isn't that the very nature of 403 discretion for the judge to exclude that?
Well, I think the issue.
Which might be different had there been like a judgment saying that it happened.
Sure. I think the issue is that we were in trial consistently going through the evidence, the comparator evidence. How were those who were making similar errors to that of the plaintiff being treated when they were called on them? There are those who were not disabled, that were not being terminated, were not being written up for those same errors. There were also those who had medical issues, disabilities going on that were being written up, disciplined, terminated. Comparator evidence is essential to an employment claim because you're never going to get an admission or the smoking gun evidence that, yeah, we don't want an annoying employee
But
with
this is not a hostile workplace claim. This is a disparate treatment claim. And the predicate for that is that the other employees are similarly situated and treated differently. That is not the case with either of these two witnesses, is it?
It is not that they were similarly situated or treated differently, but with respect to Jess Dutton, Jessica Walker, there was evidence introduced by the defendant. Exhibit 14, it was an interview of one of the branch managers, Karina Rosewell.
Was that given to the jury?
It was given to the jury.
Okay.
And the statement said, well, we never had anybody with performance issues like this except for Jess Dutton,
Well,
but she was fired too.
Didn't the defendant offer to redact that? And
I believe.
And you elected your client, you elected not to do that.
I believe ultimately the court, after the evidence was already in the record.
Well, no, the document had been admitted, but it hadn't been published to the jury yet.
I think that's correct, but we would have liked to use that evidence to then examine the witnesses, but we're precluded from doing so.
Okay.
Some of the testimony we would have elicited would have been, isn't it true that when Jess Dutton was terminated for the same performance issues, she was 8 months pregnant and had these work restrictions?
Thank you.
Thank you.
Counsel?
Good morning. May it please the court, my name is Pete Hale and I represent the appellee in this matter. This court will rarely disturb a judgment arising from a jury verdict, especially where that verdict was so rapidly and so decisively reached as in this case, and where the evidence was so strong in favor of the prevailing party. That is because the trial court is in the best position to manage its courtroom and make evidentiary rulings. And to justify disturbing such a verdict, this court must not just disagree with what the trial court ruled on, but this court must find that those rulings exceeded the bounds of the reasonable choices available to it, considering the facts and circumstances. That is the standard. And even if the trial court did make errors, the appellant must show that those errors resulted in substantial injustice or affected substantial rights such that the jury's verdict may have been swayed in appellant's favor. Not only were the trial court's rulings reasonable based on the facts and law available, but they were thoughtful. You can see from the transcript, the trial court tried to be equitable and fair and measured. so as to ensure a fair adjudication of this dispute through trial, despite some unusual happenings in the discovery process. Further, the evidence at trial was so overwhelmingly in favor of appellee, any errors, which we contend there are none, would have had no impact on the jury's findings. Further, under Rule 37, the trial court has broad discretion, as the Chief Justice noted, to award sanctions to a party based on discovery abuses. And the same standard applies, the abuse of discretion standard applies to reverse discovery sanctions. In this case, the financial sanction award was thoughtful, reasonable, and measured, proportional to the discovery abuses, many of which occurred before we'd even discovered that there was destruction of documents. And in fact, related to requests that we had sent to the court for discovery sanctions before we discovered there was destruction of documents. So that fee award was related to the discovery abuses, which the court has broad discretion to grant under Rule 37. It was certainly not beyond the bounds of reasonableness and therefore should stand. Regarding the Me Too evidence that the appellant contends was wrongfully withheld or excluded by the court, this court should affirm the judgment because of three things. One, the court was reasonable in finding that any potential evidence the appellant would have put on regarding Me Too.
Well, I see that the green light is on. Talking about the comparator or Me Too evidence, I mean, isn't that really, in an employment discrimination case, isn't that really critical to talk about when you've got an employer saying, well, really, she wasn't fired because of the reasons you're saying. She was fired because she was a bad employee, I mean, because she made a lot of mistakes. You're entitled to raise that. But aren't they then entitled to show that that's really a pretext, that really was for other reasons? And one of the primary ways of doing that is showing how similarly situated people have been treated by the employer.
That's correct, Your Honor. But what the appellant is doing is conflating comparator evidence with pretext, or with Me Too evidence and comparator evidence. The evidence they proposed putting on with Jessica Dunton and Courtney McNulty are two employees who they contend were also similarly poor performers and were also terminated for poor performance. What you're speaking about, Your Honor, is evidence, and I think it was correctly
Well, I think they're
described
not contending that they were in fact terminated for poor performance. I thought
They
the
are
point
not.
of their right. You
They
just
are
said
not
that
contending
they are.
that.
That's why I'm confused.
But the comparator evidence that you're speaking about, Your Honor, are similarly situated employees who engaged in poor performance, who are not in the protected class of the plaintiff, who were not terminated. That is the evidence of pretext that they're talking about, and there was nothing that the trial court did to limit their ability to introduce that evidence.
So are you really arguing more that there really wasn't such evidence? In other words, that it was, they didn't have the specifics of relevant evidence to introduce on that point? I'm not really sure.
They did introduce evidence, or they tried to introduce evidence such as that. For example, if I may, I can give examples. They were allowed to introduce evidence that Betsy St. Pierre had sent confidential information in error to Jessica Walker, but that Betsy St. Pierre was not disciplined for that. They introduced evidence regarding the number of warnings that Karina Rosewell had given to other employees. They introduced evidence regarding whether Betsy St. Pierre had terminated any employees who had only been issued one warning, and in fact asked, was Jessica Dunton one of those employees? So they were not precluded from asking or introducing evidence about employees who had done similar things as Jennifer Owen, but were not fired.
Can I go to the argument about opening the door? The defendant put in two exhibits, Exhibit 14 and Exhibit 36. Both of those exhibits made references to circumstances involving treatment of other employees. Why doesn't that open the door to at least give the plaintiff an opportunity to further explore that through witnesses, not just through closing arguments, but but through examination of witnesses.
Well, Your Honor, I agree that introduction of some evidence to the jury opens the door to something to respond to that evidence. The examples that you provide, Your Honor, Exhibit 14, I think, was rightly acknowledged when appellant was making her argument. The portion of Exhibit 14 that she's referring to was not put to the jury. And so the opening the door doctrine, the idea of that is when one party opens the door by introducing evidence that may mislead the jury, the other party, for the purpose of correcting any attempts to mislead the jury, is allowed to put in rebuttal evidence to correct that, to correct any prejudice.
So the evidence, so Exhibit 14, for example, was admitted, but it had not yet been seen by or published to the jury at that point. Is that correct?
The portion that they are talking about had not been put before the jury at the time appellant's counsel made her offer of proof. So there was no prejudice at that point. And when we identified that issue, we offered to redact it before the exhibit was sent back to the jury during deliberations, and they didn't take that off.
Is that the same situation with 36 as well?
36 hadn't, also, the portion they are talking about had not been put to the jury at that time. And what the court did not preclude or deny the appellant from using Exhibit 36. The court actually allowed her to read into evidence the one excerpt from Exhibit 36 she claims was the information opening the door, which I may note, I think contained triple hearsay, not related to the witnesses that we're talking about here, the Me Too witnesses. So there was very little, if any, prejudice involved in those exhibits being admitted into evidence because of the reasons I just described.
Did TNC, as part of its evidence here, attempt to suggest or demonstrate that it's supportive of its employees who have disabilities or conditions?
Town and Country, and just to make clear, in the transcript, what was put into evidence was certain efforts by Town and Country to support cancer research and employees who possibly were going through cancer recovery. That evidence was introduced by Town and Country in response to claims and testimony and evidence presented by the appellant that, one, her supervisor, Karina Rosewell, did not want her to take time off to get what she suspected to be a cancerous lesion inspected, that Heather Savage had discriminatory animus toward her when she terminated her employment, that Betsy St. Pierre had discriminatory animus toward her. And the evidence that we presented was Karina Rosewell raced in the run for the cure with Jennifer Owen on her behalf, that Heather Savage had offered items to donate during a bake sale on behalf of Jennifer Owen.
What inference is Town and Country asking the jury to draw from that? What did you want them to think after hearing that evidence?
Well, it goes to motive. It goes to state of mind with respect to Jennifer Owen. She's claiming these individuals had discriminatory animus toward her, yet the evidence shows that they supported her, that they encouraged her, they took time out of their day. And so, to the extent that opens...
So we're talking about basically Town and Country's approach, their attitude to these things, and that our attitude was appropriate here, appropriate there. Doesn't that kick the door open for them to say, well, okay, you did some good stuff there, but we have now a carte blanche to put on contradictory evidence?
I don't agree, Your Honor, that that's carte blanche to put on contradictory evidence. The opening the door doctrine states, you know, to the extent we open the door, that's the only extent to which they get to walk through it. So they were not precluded from asking about evidence or testimony in contradiction to that. And the judge had broad discretion to say, yes, they testified this way, about efforts of specific individuals that they have commented on, like it is the court's, excuse me, Your Honor, the court has broad discretion to say, listen, some of this evidence may have marginal probative value toward what you slightly opened the door to, but I am making the judgment as the trial judge presiding over this case that the threat of prejudice, the confusion, the delay greatly outweighs any probative value of these two former employees in their subjective views over the reasons for their termination. He has broad discretion to make that determination, and he made the correct determination, not just because it would have resulted in a trial within a trial, but because this Me Too evidence, this theory, had not been brought up in discovery. There had been no discovery on it. There were no depositions on it. It involved the very person who was the subject of the spoliation and discovery abuse order, which would have resulted in fundamental unfairness. We would have had to re-litigate the entire spoliation issue, because then if it centered around Me Too evidence over Jessica Dunton, we'd have to look at those text messages again and look at a different view of whether how and to what extent they are relevant, and whether more severe sanctions would have been imposed.
Is it relevant for the employer to say, okay, you're accusing me of discriminatory practices here, but look at these other cases over here where we were not discriminatory, we were very supportive, on the contrary? Is that appropriate evidence to defend the case?
I believe so, Your Honor. I think that is relevant.
So wouldn't it be
in a marginal way, in a disparate treatment case,
So
it is
yes,
marginally relevant.
The door is slightly open, but not very much?
Slightly. And so slightly does not mean they get to kick it down. It doesn't mean they get to blow the wall apart and send in two witnesses who have allegations and then put on a trial within a trial that would extend the trial schedule another week to, we'd have to reopen discovery.
So your bottom line here is this is a 403 determination?
Absolutely, Your Honor. Well within the court's discretion to say, yes, this evidence might be slightly probative. It may be. It may be slightly probative. But the court is in the best position, the trial court is in the best position to manage its courtroom and to manage the schedule that it has, and to manage the prejudice that would have resulted to the defendant, considering the prior conduct of the appellant regarding Ms. Dunton. And that court was in the best position to say, you know what, I'm making a reasonable determination, and that determination is the jury would be confused, it would prejudice the defendant. This is about Jennifer Owen. This isn't about Jessica Dunton. This isn't about Courtney McNulty. This is about Jennifer Owen.
It's about Town and Country's action taken against Jessica Owen. That's what the case is about, isn't it?
Correct, Your Honor. It was about Town and Country's actions taken against Jennifer Owen, and part of that was evidence that they introduced to try and suggest that Town and Country did not support her, and evidence that one of those events that we're talking about right now was one where Jennifer Owen stood up and said, Town and Country actually does support me and actually has been like family to me.
Thank you, counsel.
Thank you.
Ms. Quinlan?
Thank you. I just wanted to go back to the text messages themselves and the issuance or the granting of attorney's fees. Not only did the court hold that they were innocuous and that they do not go to the merits of the claim, but
And the court did not give a spoliation instruction or permit that inference in the end at the trial.
True. They did not give that adverse inference instruction, but they did approve these attorney's fees, and the attorney's fees included 12.8 hours of reviewing the 700 pages, 7,000 text messages that the defendant wanted. They got what they wanted, and then they got paid for reviewing the text messages that they wanted. If you look through the bill
So
of
do you want us to take 12.8 hours out?
I think they should all go away because these are text messages like, hey, let's get a bottle of tequila. Let's go do this. Is your daughter sick? Would you like me to get you some Tylenol? A plaintiff should not be punished for not producing private text messages with her girlfriend related to their children, their social activities, not at all
But
related.
is it unreasonable for the party who had to fight to get this discovery to think, we need to go through this very carefully because it should have been produced the first time around?
I think that's the point. It shouldn't have been produced the first time around or ever.
Oh.
I've never had a case where I've produced thousands of text messages going back and forth about where they're going to go, what they're going to do.
Weren't these text messages requested? Didn't they fall within the scope of the request?
Requested and objected to, and typically what we see is a limitation if they relate to the substance of the lawsuit.
Were they objected to, or were they disclaimed? In other words, was there a denial that those texts existed?
There was no denial that they texted each other, that the text messages were going back and forth. There was an objection to the relevance and that there was nothing related to the lawsuit itself.
But the defendant had to go through the effort of making multiple requests and then have the phone ordered, produced, so the defendant could look at it. I mean, that's sort of an extraordinary step, isn't it?
That's what we're saying. It was so extreme. I mean, the plaintiff wasn't trying to hide it. She gave her entire phone to the defendant.
At the end of the game, at the very end of the process, though, not initially.
Because there was nothing on it. I mean,
She knew that, but the other side didn't know that.
She represented to them in her deposition in response that she didn't have anything that was relevant, and the text messages themselves revealed that she, in fact, had nothing of relevance.
So should the opposing party always be required to simply rely on that representation of what the contents of their phone is?
I think we're all required, unless you have evidence to the contrary, to accept a party's assertion that their production is truthful and honest, and that if they don't have anything that's relevant or related to the request, that's what they're stuck with. I think that's the, if I may have, no.
No, we're really beyond.
Okay.
Thank you. That's why I permitted you to finish your answer. All right, thank you, everybody. Thanks for the arguments in this case. As is our usual practice, we will be taking the matter under advisement and will issue a written decision in due course. And with that, we'll be in recess for the lunch recess.